next argument that we will hear this morning is In Re PC. It's case number 18A0019M. Both parties are represented by counsel, so each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes. If you plan to reserve time for rebuttal, let me know and we will keep track of the time for you. The oral arguments are recorded, so we ask that you keep your voice up and stay behind the podium. And because in this case it does involve a minor child, we ask that you refer to the name of the child by initials. We've read the briefs and are ready to proceed if you are.
Morning, Your Honors. May it please the Court. My name is Lauren Hammersmith on behalf of minor appellant PC. There are two separate and distinct errors in this case. I'm going to address them both separately. First, PC...
You want to reserve time?
Oh, yes. I would like to reserve 3 minutes. For
3 minutes, okay, thank you.
Thank you, Your Honor. First, PC was wrongfully classified under Ohio's repeat juvenile offender statute when he had no previous adjudication for a sexually oriented offense. And second, PC was wrongfully classified as an adult sex offender registrant. To address the classification under Ohio's repeat juvenile offender statute, the requirements to be classified under 215282 are that a juvenile have a previous adjudication for a sexually oriented offense, and that was not the case here. The record indicates several times over that the juvenile court recognized that PC did not have a previous adjudication, and also the record indicates that PC was classified under revised code section 215282.
So a first-time charge of a rape would not carry a juvenile tier sex offender registration. Is that what you're arguing?
No, Your Honor. The way that juvenile sex offender registration works is that based on the age of the juvenile at the time of their offense, it determines whether they are a mandatory or discretionary registrant. And then from that point, all tier levels are discretionary. There is no offense tied to that. And I will talk a little bit more about that in my second assignment of error. A non-protunct is not appropriate in this case to fix the error that was made because it does not reflect what happened in open court. And because the issuance of a non-protunct would date back to the original disposition, it would have the effect of making PC's classification void. Because of his age at the time of his offense, PC was correctly supposed to be classified under 215283, but because he was sent to a secure facility, in this case being Ohio DYS, the proper time for classification was upon his release from secure facility, and he has not been released yet.
So that would be the proper time for classification as an adult registrant? Is at the time of this, not at the time of disposition, but at the time of release?
As a juvenile registrant, Your Honor. So if this court were to issue, or order the juvenile court to issue a non-protunct to change the classification to 215283, such classification would be void.
Did the court properly cite 83 in open court and just make a mistake in the judgment, disposition order? Is that what happened here?
No, the court referenced both 82 and 83 in both the judgment entry and in open court, but as I stated in my brief, I think the timing of the classification gives evidence to the court's intent. As I said, a classification under 83 in PC's circumstances would not be authorized under the law. So the timing at disposition under 82 gives evidence that the court was intending to classify under 82, which is not authorized because PC did not have a previous adjudication.
All right, thank you.
Turning to the adult classification, Your Honor, there is no statutory authority to classify an SYO like PC as an adult. 2152.13 D1A says that SYO sentencing is limited to the options located in Chapter 2929. Sex offender registration, all of the rules and everything for that is located in Chapter 2950. Further, sex offender definitions, all located in Chapter 2950, tie adult classifications to adult convictions. PC, with his SYO, does not have an adult conviction and will not, even if his SYO is imposed. One thing that this court was concerned with in DJ, which the state cited in its brief, was that there was no difference between adult and juvenile registration, such that the adult registration would be harmless or superfluous. The reality is that adult sex offender registration and juvenile sex offender registration are very different. As I pointed to before, the eligibility for registration is different. Not all juveniles register, whereas adult registration is tied to offense. Where juveniles have to register is different from adults. Juveniles only register where they live. Adults register where they live, work, and go to school. The public nature of the registration is different. PC's information would be online, and he would have note cards sent to the community that he decided to live in. As an adult registrant, whereas a juvenile registrant, that would not happen. And adults have restrictions on where they're able to live as adult sex offender registrations, whereas registrants, and juveniles do not. And I think the most poignant difference for PC is that as a juvenile registrant, he would have the option to ask the juvenile court to reclassify or declassify him, whereas an adult, it is a mandatory lifetime registration as a Tier 3 registrant. And the Ohio Supreme Court has already said that those kinds of registrations are unconstitutional in re CP. If there are not any further questions.
Well, there was no objection to the juvenile sexual classification, if I recall. So is this a plain error analysis?
Yes, Your Honor. The plain error was that the juvenile court classified PC under a statute that it had no statutory authority to classify him under. And the harm here was that PC did not get the benefit of sex offender treatment at DYS to determine what tier classification he should be. And that's the reasoning behind the classification needing to be at release from a secured facility. So that was the harm here.
So if the juvenile court sent PC off to DYS, PC did not do what he was supposed to do as far as the treatment, and then he was brought back for sentencing under the adult sentence. The court could at that point, and juvenile court at that point could apply the adult registration requirements on him. Yes?
Your Honor, are you asking if PC's SYO is invoked, if the court could then classify him as an adult?
Yes.
The answer for that is no.
Because here, they imposed the adult registration before he was even sent to DYS, if I remember correctly.
That is correct. So, two answers to your question. First, the adult classification issue and the juvenile classification issue are not tied together. They're separate and distinct errors. Second, just because of his nature of having an SYO, the Ohio legislature is saying that PC can get an adult sentence for having an SYO. But sex offender registration is different. One, because there's no statutory authority to classify as a sex offender registrant when a child is an SYO. And two, because Ohio law does not favor the mandatory application of lifetime sex offender classification on juveniles. And that goes back to what the Supreme Court said in Re CP. Does that answer your question?
Yes, thank you very much.
If there are no further questions, I would ask that this court reverse.
Thank you very much for your presentation, and you'll have up to 5 minutes.
Great.
Good morning, Your Honors.
Good morning.
May it please the Court, I'm Vince Bellucci with the Medina County Prosecutor's Office for the appellee of the state of Ohio. And I will just begin with the first assignment of error here, the .82 versus the .83 in terms of being used to classify PC as a juvenile sex offender. The state certainly agrees that the correct statute here is .83. There's no question about that because PC did not have a prior sex offense on his record. And the trial court, in fact, did classify PC under .83. It didn't commit any kind of error here. And it did that both on the record at sentencing and in its classification order. And I think timing is important here. That was mentioned both on the record and in the classification order itself. When PC is actually being classified, if you read it, he references, the trial court references .83. Now, later on in the record and then also in the classification order, what happened was you have the trial court basically making a statement in the past tense that this court has already classified PC pursuant to .82. So basically just misspeaking is what happened later on after already classifying him under .83. But when he actually says, when the trial judge actually says he's actually classifying you, he says you're a tier 3 sex offender. He says .83 is the statute that's referenced. And I would just mention in terms of the jurisdiction and statutory authority, this court has dealt with this before. Here, actually, in a case that I dealt with in Re DM, this was discussed in terms of the void versus avoidable order. That's 2017 Ohio 232. So pretty recently. And the fact is the court did have the jurisdiction and the statutory authority to classify PC, whether or not he happened to say .83 or .82. This is not an issue that would make the order void. At most, it would make the order voidable. And that's if there was error, but there was not error. I'm just saying arguendo, if there was an error, if this would be avoidable or not a void order. And I think that's been made pretty clear. There's a Williams Supreme Court decision that this court cited in that case as well. Now, the standard referenced here by the appellant is that saying this is plain error, and there was absolutely no objection made to this before the trial court. This was a plea. They went in, they did the sentencing. Nobody said a word. So this is plain error, and there's no plain error argument made by the appellant here. And this court has been very consistent in not constructing arguments on behalf of appellants. And certainly should not do that here when you have the appellant saying nothing more than there was error and it was plain. That's just not good enough to make a plain error argument. This is a very, very high bar. You've got to say how this error was obvious, how it changed the outcome of the case. It's not either of those things. And again, so I agree, a non-pro-tunc is not something that's appropriate here, because that would only be appropriate if the court said one thing on the record and then had essentially a typo in the order that didn't reflect what was said on the record. What happened here was .83 was referenced on the record, then .82 was referenced in the past tense on the record. Same thing happened in the order. .83 when the actual classification is made, .82 referenced in the past tense. Same thing happened essentially both on the record and in the order. There just wasn't error here. I would then just move on to the second claim, Another plain error standard here, talking about when they classify PC as an adult Tier 3 sex offender. This is an SYO case as part of his blended sentence. And first I would just say this is the whole point of an SYO, is to have both a juvenile sentence and an adult sentence, and then you stay the adult sentence. This argument, this exact same argument was made earlier this year actually in Re DJ, and this court rejected that argument. In 2018 Ohio 569, just like PC, DJ argued that the adult registration requirement applies only to people convicted of an offense, quote unquote, and a juvenile adjudication isn't the same thing as a conviction. So the same argument was made, this court rejected it. This court pointed out in that case, in DJ, that 2950.01 clearly defines a Tier 3 sex offender to include anyone adjudicated a delinquent child for committing a sexually oriented offense. And if you need even more proof, as I cite in my brief, another statute makes this clear as well. 2152.191, that statute specifically says that Chapter 2950, which deals with the sex offender registration, that whole chapter does, it says in there that chapter does apply to juvenile delinquents. So that's another place where the legislature is making this clear.
Counsel, I guess I'm just not sure about something. In regard to when the court classifies the juvenile here under the juvenile statute as well as the adult statute in regard to sexual registration, sex offender registration. So the sex offender registration, the Tier 3 with the adult, is stayed.
Correct.
Okay, and would only become applicable if he doesn't complete his sentence.
Correct. If he, for example, refused treatment or committed a new offense, perhaps.
When the adult sentence would be imposed then.
Right. And then that process would have to be initiated by DYS in conjunction with the prosecutors, and that whole thing would have to happen. But it is stayed initially up front. And in fact, the registration has to be included as part of the adult sentence because it's mandatory as part of this 15 to life adult sentence. So it has to be included when you're doing the SYO because that's the point of an SYO. This argument actually just makes no logical sense if you think about it. The whole point of an SYO, as I mentioned, an SYO sentence, a serious youthful offender, is that it's a blended juvenile and adult sentence. By PC's logic here, the juvenile court could never impose any type of adult sentence on a juvenile just because they're in juvenile court and the juvenile didn't, quote, commit an offense. That's just not what the legislature is saying to us and is intending with all of these SYO statutes. That's why you have all these special statutes, and you have these statutes even going out of their way to say that this sex offender whole chapter can apply to juveniles just the same. So the whole objective is you impose whatever sentence the juvenile would have faced, and then you stay that sentence. If the juvenile keeps their nose clean, they don't pick up a new charge, for example, the adult sentence is never imposed. But if you don't complete the adult sentence, if you don't complete the juvenile sentence, the adult part of the sentence is hanging over your head. There's a carrot and a stick. And the Supreme Court of Ohio has explained how this is meant to work. The stick is the adult portion of the sentence. But if the adult sentence can't include sex offender registration, then there is no stick. There's nothing hanging over the. Well, there is, but there's a major part of it would actually give the juvenile a huge benefit, a windfall, if the adult portion of the sentence couldn't include sex offender registration. That's just not. It's nonsensical. It's unjust, and it's not what the legislature intended with these serious youthful offender statutes. No court has ever held this to be the case. The case cited by the appellant basically just outlines the SYO process. It's helpful in that way in terms of explaining the SYO statutes, but it certainly doesn't offer any support as to what PC is trying to say here.
You're talking about NRADF?
Yes.
The Fifth District Court of Appeals case?
No, I believe it's a Supreme Court of Ohio case.
But they cite the F case in their reply briefs that says the Fifth District did hold the way they're alleging.
Right, and again, that's, the case that's more on point here is this court's own decision, where it decided this exact issue in In Re DJ just earlier this year. And I would say again, plain error. So again, we have no plain error argument even being made here, other than to say it's plain error. Again, a very high bar, wouldn't affect the outcome of this case. I think this court has mentioned actually that the juvenile requirements are, sex offender requirements for a Tier 3 offender are essentially the same as adult Tier 3 sex offender requirements.
Well, in Ray DJ, I remember that case because I actually concurred in judgment only on it. But what the court was saying, wasn't it, that a lot of these issues weren't exactly framed in front of us correctly. You know, it was whether it's classify or adjudicate, and then it was like nobody's made the argument that they aren't the same, penalties or the same registration, if there's no difference. So really, an argument can be made those issues were not clearly in front of this court in Ray DJ.
Yeah, and I read that sort of to imply, though, that they're essentially the same. I agree. Well, the court, you were not directly saying that, I don't think, but I think you were sort of making the point indirectly by phrasing it the way that you did there. That sort of, what are we talking about here? This is, especially if you're talking about plain error here. I think this would just defeat the entire purpose of serious youthful offender, of the serious youthful offender statutes. It just wouldn't make any logical sense, and it would really destroy the purpose of the SYO, which is to have this carrot and stick. Like I said, to have this this full adult sentence, not just the prison sentence, but the lifetime registration. It can't possibly be that would replace the juvenile requirement when they don't complete their sentence, and then they're rewarded for that by no longer having a registration requirement. That absolutely is not the intent of the statutes. No court has said that. Certainly this court has not said that, and I think that argument was rejected in the case earlier this year.
There was a Supreme Court decision in Ray, was it CP? Does that have bearing on this case?
I don't believe it does, Your Honor. I don't think it's on point to this case. If you look at it again, I think it's more just talking about general statements about what the serious youthful offender statutes do. I don't think, in no way did the court say that you can't, as an SYO, make a juvenile give a juvenile an adult registration requirement. Absolutely, that is not at all what's being said there. So I would say no, that is absolutely not on point.
Counsel, I have a question for you, and I legitimately don't know the answer. When a juvenile court imposes and then stays the adult portion of the sentence, is a juvenile court, like an adult court, also required to give post-release control warnings?
I don't believe that's part of it.
Okay.
My understanding is no.
Okay.
I'm not 100% sure on that, though.
Me neither.
But if I had to say one way or another, I would say no. If there are no further questions,
Thank you very much for your presentation.
thank you. I would just ask the court to affirm the judgment of the trial court. Thank you.
Counsel, you've got 5 minutes.
Great, thank you. First, to answer your question, Your Honor, the court is required to impose post-release control warnings. I would point this court's attention to State versus Billiter. I have not had the chance to brief that in my briefs, but I can provide supplemental briefing if this court wishes.
No, I guess then, since you're saying that the court is required, I mean, it's basically just to put the juvenile on notice of what would happen if that sentence got imposed, correct?
Correct, Your Honor.
So why is the notification of the sex offender registration any different? Because it would not come into play unless the sentence is imposed. Is that correct?
The adult registration would not come into play unless PC's adult sentence was invoked, Your Honor, but I would point this court's attention to 2152.13D3. It says the juvenile has a right to appeal serious youthful offender sentences, including the adult portion of the sentence, and the Court of Appeals should consider the adult portion as if it were not stayed, which gives this court authority to review the adult portion of PC's sentence. The state argues that there's no difference between juvenile and adult registration. I would just refer this court to my reply brief, pointing out the differences, the stark differences between juvenile and adult registration, and argue that PC is not getting a benefit if he were to not have adult registration. 15 years to life in adult prison is certainly not a benefit. To address the state's argument about this court's decision in DJ. DJ is different from PC. PC has not had his SYO invoked yet, and at the point that DJ was before you, his SYO had been invoked. Further, as Judge Carr pointed out, this court might have been having trouble with the differences between the adult and juvenile registration, and as I pointed out during my argument, those are very different. Further, In-Ray CP does have bearing on this case. In-Ray CP looked at the constitutionality of 2152.86, was the juvenile sex offender registration provision that told juvenile courts how to register SYOs. The Supreme Court found that provision unconstitutional in its decision in CP, but the underlying reasoning applies here. Mandatory application of lifetime sex offender registration does not apply to juveniles with SYOs. So I would point this court to that decision. And then further to talk about In-Ray DM, this court held that if there was a lack of statutory authority, or if there was statutory authority and jurisdiction to classify the juvenile, that the wrong classification was avoidable error that must be brought on direct appeal. We're bringing this case on direct appeal. And further, there was no statutory authority to classify PC at the time that he was classified at all under any statute. If he were to be classified at all, it would be upon his release, and actually he's going to be a mandatory registrant, but it must be at his release from DYS, which is not happening yet.
But it cannot be after release.
Correct, Your Honor. If there are no further questions, I would ask that this court reverse the juvenile court's classification decision regarding his juvenile classification and adult classification.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a decision in due course. The clerk of courts will mail a copy of the decision to each of you on the day it is released, and also the opinions are posted on the Supreme Court of Ohio's website. Thank you both again for your presentations.